3, 2, 1, start. Admittedly, the penalties of permanent withholding of pension for a lifetime and forfeiture of entire gratuity does not feature in Regulation 62 of the said service regulations, and accordingly the said punishments as imposed are absolutely without jurisdiction. Stop. Furthermore, the proceedings were conducted under the provisions of the said service regulation and not under the DCRB regulations, and the respondents cannot justify imposition of punishment of withholding of pension and forfeiture of gratuity by drawing reference to the DCRB regulations. Stop. Such jurisdictional error towards imposition of punishment renders the impugned order of punishment to be unsustainable in law. Stop para. The petitioner has categorically stated in the appeal petition that the punishment imposed suffers from the vice of misuse of authority, and that as such it cannot be said that the petitioner did not urge the point of jurisdictional error. Stop. The said issue was, however, not taken into consideration by the appellate authority, and it has merely reiterated and affirmed the multiple punishments imposed by the disciplinary authority. Stop. The issue called out by the appellate authority as to whether the participation of the petitioner in the seminar of IEEMA was an authorized one is itself unfounded, inasmuch as the invitation was admittedly a personal one, and the leave applied for by the petitioner for attending the said seminar was also approved by the respondents themselves. Stop. As such, the order of the appellate authority suffers from total non-application of mind. Stop para. The right to reputation comes within the purview of fundamental right. Stop. The petitioner reached the post of superintending engineer by the dint of his merit through rendition of service for more than 20 years, having a spotless career without any sort of misconduct in course of his past service, and a person who has devoted himself in the discharge of his service and has earned reputation cannot be ousted through imposition of a stigma on the basis of perverse findings. Stop. An employer also has an obligation to protect its employees from being victimized, and it cannot render an officer of the rank of superintending engineer so vulnerable that by drawing an imaginary nexus of the person concerned with a participant in a tender process, he cannot be ousted from his service and deprived of his retirement benefits, including gratuity, which is the highest punishment in the service jurisprudence, and throughout his life he would have to carry the stigma of having stooped down to a business organization. Stop para. The foundation of the charges was on the basis of the facts that the petitioner had attended the presentation of IEEMA in New Delhi on the basis of a personal invitation, and that no prior application for leave was made for attending the said presentation on 17th April, 2008, and that air tickets for the to and fro journey was availed from the travel agent of SML, and on the rudiments of the said facts the inquiry was conducted, and the petitioner has not denied the said facts. Stop. It is well settled that the facts admitted need not be proved, and only on the fact that the petitioner did not tender oral evidence pertaining to the said admitted facts, it cannot be held that the petitioner's defense in the proceeding is unsustainable. As such, I do not find any substance in the argument of Mr. Mitro that the failure on the part of the petitioner to tender evidence in the proceedings goes to establish the charges framed. Stop para. In service jurisprudence, dismissal from employment is akin to civil death. Stop. The sequence of facts reveals that the respondents have proceeded in an arbitrary manner and has imposed punishment not only of dismissal but also towards withholding of pension and forfeiture of gratuity when admittedly there has been no pecuniary loss to WBSCDCL. Stop. The allegation of lack of integrity is also unfounded, and the respondents have proceeded with a mindset to penalize the petitioner. Stop para. The petitioner's conduct is irreproachable, and his understanding of responsibility and adherence to discipline is not questionable, and his reinstatement would not tantamount to foisting a cantankerous and abrasive officer upon the employer. Stop para. For the reasons discussed above, the entire disciplinary proceeding, including the order of suspension dated 29th April, 2008, the charge sheet dated 25th May, 2008, the inquiry report dated 26th December 2008, the order of punishment dated 2nd June, 2009, and the appellate authority order dated 10th November, 2009 are set aside and quashed. Stop. The respondents are directed to reinstate the petitioner within 6 weeks from the date of communication of this order and to start payment of the petitioner's monthly salaries and other allowances month by month. Stop.